I also welcome the dignitaries on the dais, off the dais, including our learned ASG, Ms. Madhvi Diwan, Senior Advocate Rana Mukherjee Sir, Senior Advocate Rakesh Khanna Sir, C. Mohan Rao Sir. I'm so thankful for all of you to have taken time for attending this function. The topic for today's function is embracing unit equity in justice delivery system, way ahead. This reminds me of what Daniel Marichild once said: a woman is the full circle. Within her is the power to create, nurture and transform. जिम्मेदारी संग नारी भर रही है उड़ान, ना कोई शिकायत, ना कोई थकान. With this, may I call upon Senior Advocate Shri C. Mohan Rao ji, along with Ms. Ankita Chaudhary and Ms. Bharti Tyagi, to kindly come up on stage to felicitate our Honorable Chief Guest, Honorable Justice Hima Kohli. Thank you, everyone. Usually, when we celebrate the Women's Day, it has become a tradition that we remember all those who are working tirelessly, and sometimes we don't even notice that they are there. They are the support staff. The women staff who are there in our library, who are there in our ladies' bar room, in our canteens, the Safai Karmcharis. I would now request Monica ji, Manoj ji, Alka ji, she's in the ladies' bar room, Premlata ji from Library 1, Sudha ji, lunch room, Sapna ji. I would request everyone to give a round of applause for her. Sapna ji from Skora, Kavita ji, she is with her entire team. She's here with her 30 members team. They all are there, but she's representing the team. And we also have, please come up again. I would request ma'am to kindly felicitate them. A small token of appreciation from the Supreme Court unit of Adhivakta Parishad. We also have nurse Ms. Kalpana, who's working in the dispensary of the Supreme Court. She's always there when we fell sick. Clapping should not stop. Thank you very much. They were all very thrilled when we told them that Honorable Justice Hima Kohli is going to hand over the token of appreciation to them. They were all nicely dressed up and they were all waiting here from 4 o'clock. You can see the entire team, the Safai Karmcharis, they are all here in their dresses. Thank you very much, ma'am. It is indeed a great gesture. Thank you. I would now request the General Secretary of the Supreme Court unit of Akhil Bharatiya Adhivakta Parishad to kindly give us an introduction about the organization.
warm welcome to everyone. Respected dignitaries on the dais, off the dais. Adhivakta Parishad is an all-India organization of advocates. This organization is part of a larger family of patriots committed to the cause of national renaissance. The organization makes timely interventions in justice delivery system and makes contributions to law-making process for the welfare of the citizens and rejuvenation of vital institutions of the nation. Adhivakta Parishad is making efforts to train advocates to become skilled lawyers with social commitment and patriotism for a strong, effective and accountable justice delivery system immune to external pressures and other digressions. Adhivakta Parishad was established as under a federal umbrella organization in 1992 with the convergence of several groups of lawyers actively working across the country in different states and formalized as Akhil Bharatiya Adhivakta Parishad. The advocates of Akhil Bharatiya Adhivakta Parishad are helping the Sajan Shakti to move forward in their respective paths with the common objective to make the country prosper. Hundreds of cases have been fought by members of the Adhivakta Parishad on behalf of Vanvasis, fishermen, street vendors, temple committees, animal welfare organizations, farmers, etc., right from Tehsil level trial courts up to the Supreme Court of India. Various organizations and persons are continuously being guided, advised by Adhivakta Parishad in order to give inputs whenever new legislations and statutory rules are being promulgated by the legislature or the statutory authorities. For the last 30 years, Adhivakta Parishad has got consistent support and guidance from senior and experienced members of various social organizations and judicial systems. It has identified the following core areas for immediate attention of all concerns. 1. Social justice. 2. National security. 3. Social evils. 4. Cultural onslaught of colonial Western models. Challenges faced by women. Protection of human rights, etc. The Adhivakta Parishad has been organizing study circles wherein 3 generations of advocates regularly meet to discuss the various statutes, case laws and issues concerning the society. Nearly 600 study circles are functional throughout the country as on this date. During the COVID-19 period, nearly 3,000 webinars were conducted by various units of Adhivakta Parishad for knowledge sharing. The Adhivakta Parishad has also been organizing Nyay Kendras on the concept of providing free legal aid to the poor, downtrodden and deprived sections of the society by going amongst them and advising them in the problems being faced by them. The Adhivakta Parishad also conducts regular workshops for enhancing the skills of the advocates with the support and guidance of all senior members of the bar and academicians from various law faculties. The Adhivakta Parishad has been trying to create an interface platform where the social organization, advocates and academicians interact to bring necessary changes to the legal system and to make it more people-friendly, speedier and cost-effective. The Adhivakta Parishad publishes its quarterly magazine, Nyay Prava, containing articles on various social legal issues which are contributed by honorable judges, advocates, academicians, law students and researchers. Thank you.
Thank you, Nachiketa ji, for aptly putting in words what the organization is all about, how we function, what is our motto, and what values we stand for. Thank you very much. I would now request Senior Advocate Mr. S.N. Bhatt to kindly give us his viewpoint on what he thinks about women empowerment and today's topic in recent times.
Justice, ma'am, we are really happy and honored to have you. It's a very warm welcome. Friends, we are here today to discuss a very important topic. Embracing equity in justice delivery system way ahead. I was discussing about today's topic with one of our guests today, Hima, who is a professor in Delhi University. She threw a very interesting light on the choice of the topic and the way it was worded. He said it is equity, embracing equity in justice delivery system. It is not, the word used is equity, not equality. And I asked her, what is the difference that you really make between the two words, equity and equality? And interestingly, she told me that equity is something that people who are already equal demand, and therefore, when you are asking for equity, it presupposes that the person who is asking for equity is already equal in all measures. But somehow he has not been treated in an equal manner. Therefore, the topic is well chosen and the phraseology used is also very well worded, and it focuses our attention to the problem that is faced by women in the justice delivery system today. Our chief guest today would be in a much better position to really expand on it, because she has come through the system, having experienced it from the first day she entered the system, having scaled the heights to be the judge of the highest court of the country. When we ponder upon today's position with regard to women and their role in the justice delivery system, one thing that really crossed my mind was what was the position of women in Indian society in times past. Sat as a judge in a great debate between Sri Adhivakta and Mandal Mishra. That was a very great instance of recognition of a woman's intellectual capacity as well as her ability to deliver impartial and fair judgment. I would like to really dwell upon that incident in a little detail, because it throws a lot of light on the role of women and the way in which women were treated and respected during those days. We can take inspiration from that instance. You will be aware of the great debate between two great philosophers and intellectual giants, Sri Adhivakta, who was the greatest exponent of Advaita philosophy, and Mandana Mishra, the towering figure as far as Mimamsa philosophy was concerned. Now, Adi Shankaracharya and Mandana Mishra agreed to debate high philosophical issues against each other, and it was decided that in the event of, as you know, all would be knowing that Adi Shankaracharya was a celibate, he was a sannyasi in pursuit of eternal truth. Mandana Mishra was a householder. He was married and he was fairly advanced in age at the time of when this debate took place. When the challenge was made by Sri Adi Shankaracharya to Mandana Mishra for this debate, Mandana Mishra said that there would be two conditions for which Adi Shankaracharya agreed. One of the conditions was that in the event of ultimate verdict coming against Adi Shankaracharya, he would adopt the way of life of the winner, that is Mandana Mishra. And the second was that second condition was that Mandana Mishra would take his own wife as the judge for the event. Adi Shankaracharya agreed to this. Now, Adi Shankaracharya had the kind of great faith and confidence in the ability of Ubhaya Bharati, that she would be impartial as well as fair and would have the intellectual capacity to give a fair verdict. Ultimately, the debate took place. It was a great debate of great polemics between two great giants. And Ubhaya Bharati ultimately declared Adi Shankaracharya as the winner and gave a verdict against her own husband. This shows that even in the days, in olden days, in our past, our society held women in the highest of regard, respected their intellectual capacity as well as their acumen to give impartial and fair judgment. Therefore, we don't have to really look far away for the purpose of taking inspiration with regard to women's role and their ability to pursue intellectual as well as mental acumen. Therefore, we have to take our own traditions forward in order to achieve whatever we lack today in the field of women's empowerment. With these words, I would request our chief guest to come forward and the introduction of the chief guest, and thereafter there will be a request for her to come forward and give her.
Thank you, sir. Although I agree that our Honorable Chief Guest does not require an introduction, but I'll just do my duty and I will call Advocate Swati Garg to kindly give a brief introduction of our Honorable Chief Guest.
Even though I'm sure all of us present today are very well aware of the esteemed Chief Guest repertoire, I still take this opportunity to share with you her remarkable and extremely luminous courage. Honorable Miss Justice Hima Kohli was appointed as Judge of Honorable High Court of Delhi in the year 2006 and then went on to become the first woman Chief Justice of Telangana High Court. And the ninth, and as if that was not enough, the ninth woman to be elevated to the Honorable Supreme Court in its history of 7 decades. Her deep erudition and powerful exposition of the principles of law brighten up the legal firmament of the Honourable Supreme Court of India, from which all courts in this country seek ultimate light and guidance. Honourable Miss Justice, during her tenure as a judge, has passed some remarkable orders and judgments that include protecting the identity of juvenile accused of crime, calling for inquiries into the detention of prisoners who had already been granted bail, provision of facilities to enable visually challenged people to study in the government educational institutions, and many more. Honourable Ms. Justice Kohli also monitored the Delhi government's response to the COVID-19 pandemic in India and gave directions to the central government and the ICMR for allowing and approving private laboratories to conduct testing in relation to the pandemic that paved the way for millions of people to get tested and be safe in one of the worst phases in the history of human evolution. Although we are, at this time, celebrating the International Women's Day, Innovation and Technology for Gender Equality, we cannot but help feel proud of the fact that India has the oldest judiciary in the world, and the
My apologies that the program that was to commence a little earlier had to be delayed a bit, and you have been so patient and graciously waited. It was a little beyond my control. There was a set of professors from Oxford who Honourable the Chief Justice of India had invited to the Supreme Court, and I was one of the members in that committee. It is still going on. I took the liberty without any contempt, facing any contempt, of actually moving out of that discussion and joining you here. So again, my apologies. Mr. Bhatt, Senior Advocate, Mr. Natiketa Joshi, Ms. Rashmi Singhania, Ms. Archana Pathak Dave, Mr. Bharat Kumar, Ms. Madhuri Diwan, learned AST, Mr. Khanna, Senior Advocate, I can see Senior Advocate. There are so many of you here who I can name. I wouldn't. Otherwise, we'll be here till dinner time, I guess. But it's a pleasure to see all of you, advocates, friends from the media, ladies and gentlemen. I start by complimenting the organizers for selecting this nuanced topic for discussion. Mr. Bhatt did touch upon it. Ordinarily, we talk of equality and not necessarily equity. So, this is my thought process that I share with you. The Indian justice delivery system has long stood as the bastion of equity, equality, and access to justice for all. At its core, the system seeks to ensure fairness, impartiality, and justice in the distribution of benefits and burdens. The Constitution of India guarantees the right to justice as a fundamental right, and the Indian judiciary has no doubt played a pivotal role in upholding this promise. The subject of this addresses the concept of equity and how courts have ensured fairness and impartiality in the justice delivery system. So most of us and many people mistake equity for equality and vice versa. But that is not so. One must recognize that equity serves as the vehicle that propels us towards the ultimate goal and destiny of equality. Interestingly, the word equity has not been mentioned in the Constitution at all. Yet it permeates the very essence of a fair Again, in part 5 and 6, when the references to the state and the union and the parliament and the legislature in the context of equal both, but equity is not mentioned at all by the constitution makers. Equity is often described as a fairness or justice, in the distribution of resources, opportunities and benefits. In the context of the justice delivery system, equity would mean that everyone is treated fairly and each one has equal access to justice. True equality cannot be achieved without equity. This is because equity requires more than just equal treatment. It calls upon us to recognize and address the systemic barriers and discrimination that prevent the oppressed, the exploited, and the marginalized communities from accessing the same opportunities and benefits as others. It recognizes that different individuals and communities have different needs. They have different experiences, and that equal treatment may not necessarily result in equal outcomes. The principle of equality is that golden rule that is imbued in the very soul of the Indian justice delivery system. It stands for fairness, egalitarianism, impartiality, and a just distribution of benefits and burdens. The principle of equity ensures that justice is delivered fairly and impartially. You just heard Mr. Bhatt's narrative of that debate, and what are the words he ended with? That the wife of one of the participants who went to participate, Mr. Mishra, was fair and impartial. And that is what equity is about. So while the Constitution of India guarantees the fundamental right to equality and prohibits discrimination on grounds of race, caste, religion, sex, place of birth, the principles of equity is that natural law recognized by courts which ensures that all individuals are treated equally under the law and have equal access to justice. To quote Dr. Naheem Dosani, a palliative care physician who has summarized the distinction between equity and equality so simply, and I'm sure it will appeal to you, equality is giving everyone a shoe. I repeat, equality is giving everyone a shoe. Equity is giving everyone a shoe that fits. And that is the point distinction. The role of the Indian judiciary in promoting equity. The Indian judiciary has played a pivotal role in promoting equity in the justice delivery system. The power of judicial review exercised by the Supreme Courts and the High Courts allow them to strike down any law or executive action that violates the Constitution or the fundamental rights of the citizens bestowed under the Constitution, and has expanded through time by meaningful judicial interpretation. The judiciary has also jurisprudentially developed various principles of equity to ensure that justice can be delivered fairly, impartially, and objectively. So one of the key elements of equity is access to justice. Every individual must have access to legal remedies, regardless of their social and economic standing. Achieving equity in access of justice in India, to my mind, is a social call. We as a society must address the challenges that stand in the way of ensuring that every individual has access to legal remedies. One of the most significant barriers to access to justice in India is the lack of awareness of legal aid programs being run by NALSA, by SALSA, and several other organizations like the Parishad. We've just been told how many of programs they have organized and how they have reached out to assist those who are in need of legal assistance. Legal aid is critical to ensure that individuals who are unable to afford lawyers can still seek legal recourse. This includes providing free legal aid to those who cannot afford it and improving the infrastructure of the existing legal aid programs so that they are accessible to all individuals, particularly those living in remote and inaccessible areas or rural areas or are not aware of their rights. To share with you some data, The data reveals that in the current financial year, from April to December 22, 3.88 lakh legal awareness programs have been organized by NALSA and SALSAs across the country that have been attended by 5.74 crore persons. 2,16,000 odd persons have been extended legal aid to panel lawyers. 4,70,000 persons have been given legal advice and counseling, and almost 2 lakh persons have benefited through other legal services. But when we look at our vast population, all this seems like a drop in the ocean, and we will have to say that this is work under progress. Another significant challenge is the long delays in the justice delivery system. We all hear about it, and as being part of the legal fraternity, often this question is posed to so many of us, both on this side and that side, particularly lawyers who have to contend with their clients wondering why their cases are not being taken up, why are they not being disposed of, why are they not being heard. To address this challenge, an increased focus is required on streamlining the justice delivery system and reducing the backlog of cases. There are several reasons for the mounting arrears. This includes a skewed judge population ratio, a large number of vacancies, a high inflow of cases, increased citizen awareness of their rights, lack of infrastructure to set up courts, and the enactment of new legislations. I may hasten to clarify here that a pending case does not automatically add to the arrears unless and until it crosses the acceptable timeline for its disposal, depending on the nature of the litigation. It is also important to recognize the role that technology has played in improving access to justice, and all of us have been beneficiaries of that, particularly during the COVID times, and even now through the hybrid mode. The use of AI, such as online dispute resolution mechanisms and virtual courts, have gone a long way in streamlining the justice delivery system and making it more accessible to individuals situated in remote and rural areas. Expanding the digital footprint in this area is imperative, and that is also a way forward. Coming next to the application of principles of equity in prominent cases decided by the Supreme Court. The Indian judiciary has applied the principle of equity in several judicial verdicts. Since we have assembled today to celebrate the International Women's Day, permit me to highlight a clutch of women-centric decisions that demonstrate that application of the principle of equity can ensure a fair and impartial outcome for the society, and more particularly, achieve that equality goal for women. I'll start with the well-celebrated Indra Sani's case, which is a significant case in that the issue of reservation in India was highlighted. The Supreme Court had upheld the validity of reservation for the SC and ST in public employment in educational institutions. It was observed that the principle of equity required that affirmative action should be taken to redress historical injustices and ensure that all individuals had equal access to opportunities. The court observed that reservation was necessary to address social and economic inequalities faced by the SC and ST communities and to ensure that they had equal access to public employment and education institutions. It was also opined that reservation was a tool for achieving social justice and was a legitimate means to overcome the effects of the historical discrimination and social exclusion. Another case, Vishakha and others, was the state of Rajasthan. This was a case of the year 1997, a landmark judgment. It dealt with the issue of sexual harassment of women at the workplace and recognized that it is violating the fundamental right of equality guaranteed under the Indian Constitution. So this was again an expansive interpretation of the fundamental right by the Supreme Court. The court had laid down guidelines to prevent and deter sexual harassment at workplace, including requirement for employers to establish internal complaints committees, the prohibition of retaliation against complainants, and the obligation to provide a safe and secure work environment for women. This case has had a profound impact on the subsequent legislation that led to the enactment that took place in the year 2013. So the guidelines were good from the date of the pronouncement of the judgment till the legislation took place in 2013. And it couldn't be more innovative. Incidentally, every court has an internal complaints committee. You're all aware of it. We recently, on the occasion of the International Women's Day also, as chairperson of GICC, I thought we should celebrate this particular occasion. It was such a pleasure to see so many of you participate as audience in that play that was enacted by none other than advocates, and in a song that was sung by none other than the staff of the Supreme Court. The third case that I propose to highlight is the Geeta Hariharan case. In this case, the petitioner, a married lady with a son, had applied to the Reserve Bank of India for bonds to be held in the name of the minor's son, and she had signed the application as his guardian. The RBI had turned down the application and told the petitioner to either forward the same signed by the father or produce a certificate of guardianship from a competent authority in her favor. The assumption was that the petitioner's husband was the natural guardian of the child, which was based on Section 6A of the Hindu Minority and Guardianship Act. Upholding the plea for gender equality enshrined in the Indian Constitution, the CEDAW and UDHR, the Supreme Court had given an expansive interpretation to the word after in the provision 6A and had upheld its constitutional validity by declaring that both the father and the mother are natural guardians of a minor Hindu child, and the mother cannot be said to be a natural guardian only after the death of the father, as that would not only be discriminatory, but will be against the welfare of the child, which is the legislative intent of the Act. The third and a recent judgment is of July 22, 2022 that I propose to share in the case of Akila Lalita. The Supreme Court has declared that a mother, being the sole natural guardian of her child, has the authority to determine the child's surname, even after the death of her first husband. She cannot be prevented from including her child in her new family and selecting the surname of the child. The court has also asserted that natural guardians possesses the power to give the child up for adoption. I come next to the Air India Cabin Crew Association case, which was of the year 2003. Here, the Supreme Court, while acknowledging the fact that the Constitution forbids the state from discriminating against citizens based solely on their gender, clarified that this provision does not prevent employers from providing special treatment to women in employment if they request it. The Constitution also permits employers to consider the gender of the employee when making employment decisions, if it is a part of the legally authorized affirmative action plan, reiterating the fact that Articles 15 and Article 16 of the Constitution do prohibit discriminatory treatment. It was clarified that they do not forbid preferential or special treatment of women, which is a beneficial measure. The conclusion was that a regulation that discriminates based on sex to safeguard women's interests cannot be treated as unconstitutional. I now come to the case which we know as the dance bar case. The title is Indian Hotels and Restaurant Association. This was a case decided in the year 2019. This case dealt with the constitutional validity of certain provisions of the Maharashtra provision of obscene dances in hotels, restaurants, etc., and protection of dignity of women at workplace. Is a 2016 Act and the rules framed thereunder. The case challenged conditions imposed under the Dance Act. The Supreme Court held that the applications for the grant of a license should be considered with an open mind and without imputing any moral standards, so that there would not be a complete ban on staging dance performances at designated places. It was declared that an absolute ban on dance performances in bars throughout the state was illegal and infringed upon the fundamental rights protected under Article 14, 19 and 21 of the Constitution. As a result, the Supreme Court upheld the ban on obscene dances, and that included sharing of currency notes, etc. on dancers, but at the same time, it struck down the ban on serving alcohol in dance bars, as also the enforced separation between discotheques and dance bars, and conditions relating to the character of the person applying for the license. Really speaking, it recognized the right of a woman to go for a vocation which she wanted, without legislative impediments. I come next to the famous Babita Punia case. A recent and an immensely significant milestone is this decision to provide permanent commission to women who were earlier offered only short service commissions in the Indian Armed Forces. This landmark judgment has emanated from a judgment of the Delhi High Court rendered in the year 2010, finally upheld by the Supreme Court in 2020, and has highlighted the importance of fairness and equality in all spheres of the armed forces, including the process of commissioning and promotion. Senior Advocate Bala, we still call him Captain Bala, is here, and he's been through the whole road from day one till the matter actually ended in a judgment, and the lingering issues which continued till as recently as 3 months ago, which have been brought to a closure in this case. And I'm glad to share with you, which I was told at the recent Armed Forces conference which was conducted, that against 2,500 vacancies, I was told more than 1 lakh women have applied this time in the armed forces. So this decision is a testament to the growing recognition of the value that women can bring to the armed forces. Offering permanent commission to women is not just about fair play and equity, which are priceless virtues in their own right. It is also about recognizing the unique skills and abilities that women bring to the armed forces, which is a different perspective, a different set of experiences, and a different set of skills on the table. Lastly, one more. Arunachal Gowda, one more before the last. In 22 of January, the Supreme Court in this case determined the self-acquired property of a Hindu male who dies without leaving a will would be inherited rather than succeeded, and his daughter would have the right to inherit such property. This decision reflects a succession scheme that prioritizes the daughter's rights to her father's separate property in line with the principles of proximity and equity. The judgment establishes a scheme of succession that is in alignment with the rule of proximity and entitlement of the sole surviving daughter to her father's separate properties, even as far back as prior to the enactment of the Hindu Succession Act 56. Overall, this ruling is consistent with the concept of equity in the Hindu succession law, aimed to distribute property in a fair, equitable and just manner. Prior to this deliberation, in August 2020, in the case of Vineet Sharma, the Supreme Court has expounded on a Hindu woman's right to be a joint legal heir and inherit ancestral property on terms at par with male heirs. Lastly, X versus Principal Secretary Health. This is a recent landmark ruling pronounced by the Supreme Court in September last year, where it has affirmed that all women, regardless of their marital status, have equal access to safe and legal abortion up to 24 weeks of gestation. The decision is a significant step forward for gender equality and reproductive rights in India, and sets a powerful example for other countries facing regressive trends in abortion access. By recognizing and protecting the woman's right to choose, regardless of their marital status, the court has taken a critical step towards promoting gender equality and justice for all individuals, regardless of their gender and social status. Overall, this ruling reaffirms the principle of equity in healthcare and underscores the importance of ensuring equal access to essential medical services for all individuals. It is a significant step forward for women's rights in India, bucking the trend in other, even developed parts of the world where abortion access faces new restrictions. Significantly, and that is the point I will make after referring to all these judgments, except for the Vishakha case, where the 5 judges bench included a woman judge, all the remaining judgments that I have just referred to here do not include a woman judge. The author of these judgments are male judges, and the benches were all male. So this shows that the stereotypes in categorizing men and women should be avoided. The word she does include he, and her does include he, and it is the men who are forward-looking, who are evolving this jurisprudence and expanding it through judgments, who must be congratulated and acknowledged for this. And I would be failing in my duty to recognize that even today, in a house full, the majority are men, and that is how we celebrate International Women's Day. To conclude, equity is not just a buzzword or a slogan. It is the very foundation on which the edifice of truth is built. Without equity, equality will remain a pipe dream. To achieve true justice and fairness in our society, each individual must have equal access to opportunities, and everyone must be treated with dignity and respect which they deserve. The Indian justice delivery system has evolved over the years, and we have all been part of that growth. And the principles of equity and justice have played a crucial role in this evolution. The Supreme Court and High Courts have been instrumental in upholding these principles and laying down several guidelines and precedents to ensure that justice delivery system remains just, remains equitable, thereby working towards the equality goal. As we celebrate the International Day of Women, it is a time for us to reflect not just on the 8th of March of every year or the month of March of every year, but throughout the year on a role that equity plays in achieving true justice and equality in our society. Equity is the cornerstone of a or their socio-economic status. It is a cardinal principle that ensures that everyone is treated fairly, impartially, and that no one is left behind in the onward growth of the society. It is a recognition of the fact that women, who constitute almost 50% of the total population in India, are going to dominate the workforce in the next few decades, are given their place under the sun, that they enjoy equal rights and privileges at par with men, that they are not oppressed mentally, physically, or emotionally, that they are empowered to fight for the goals they choose to set for themselves, that their dreams can take wings, and that they can freely march to the beat of their own drum. Thank you.
Thank you very much for such thoughtful words, ma'am. In fact, the concept of equity has been enunciated so well in your speech today, and so many judgments ma'am has read to us, which have created a way for women empowerment. Thank you for that enlightening speech, ma'am. In fact, we at Akhil Bharatiya Adhivakta Parishad also work tirelessly towards the development of one and all. Recently, in our 16th National Conference, which was held at Kurukshetra, Haryana, we had passed a resolution which was to provide adequate representation for women in bar councils and government panels. So, since the membership of women advocates has increased considerably for over the last 10 years, and Akhil Bharatiya Adhivakta Parishad feels that a provision shall have to be made for reserving some posts in the Bar Council of States as well as in Bar Council of India. This shall be done immediately by amending the Advocates Act and relevant rules and regulation. Similar was with respect to the government panels. So we also try whatever in our might we can do so that there is a balance, since we are equal stakeholders now in the justice delivery system as well. So equal opportunities, and equity is the right word we should all be choosing. And that one example which ma'am gave of the shoe. So one size does not fit all. So we have to have different sizes for different people, for different women. Thank you very much. Since Honorable Miss Justice Nagarathna could not join us today, as the court is still sitting, but she has sent us her speech, and I would request our advocate Sonia Dhamija ji to kindly read that for us.
Good evening and namaskar. This is a speech by Honorable Justice Nagarathna. I take liberty to read it. The speech reads as this. I am delighted to be addressing this august audience at the International Women's Day celebrations organized by the Supreme Court unit of Adhivakta Parishad. I am happy to note and acknowledge that the Parishad has taken up programs to enhance skills and ethics of younger generation of advocates. The Constitution of India is focused on creating a responsive state that is geared towards enhancing public welfare and constructing a just society. The guiding light that drives the Constitution's quest towards a set objectives is the value and principles of justice, more particularly social justice. The guiding principles for this lofty vision of securing justice may be found in the diverse facets of equity. Equity represents higher legal standards and greater individualization in the application of law, or the principles of equity in rendering justice. The fusion of common law and equity in the common law world has, in my view, softened the former and rendered it more accommodative and inclusive of the needs of justice. The cherished image of the lady being the symbol of justice, donning a sword which represents power, scale which represents a balance, and a blindfold generally accepted as representing impartiality, stands in our mind alongside the aspirational promise of a fair justice delivery system. Our justice system was formed in the backdrop of deeply pervasive hierarchies which were maintained by structures that took various forms, such as class, caste, gender, etc. It is important to understand that structural inequity manifests in concrete ways. Inequity is not an abstraction. Embracing equity in this context would mean re-examining prevailing assumptions around legal service and justice delivery. The pandemic has challenged traditional models whereby clients and litigants are required to come to providers. Virtual proceedings now allow lawyers and courts to connect with people where they are. Increasingly, legal and justice service providers, including judges and courts, need to look to communities where they can help, which often means bringing services directly into those areas. If the justice system is rigid and follows a siloed approach to problem solving, there exists the possibility that broader social and life contexts are ignored, and this results in inequity. Diversification of the legal profession is critical to dismantling barriers to equity. Homogeneity in the profile of lawyers and judges would create a negative loop wherein new generations do not see themselves as having a place in the system and in turn do not pursue the profession, pinching the pipeline at the earliest stages. The judiciary at every level is required to be sensitive, independent, and free from biases. While I am conscious of the fact that there is no single point antidote that may be applied to ensure the same, I am sure that by promoting gender diversity in the judiciary, thereby diversifying the life experiences of those who adjudicate cases, will be moving several steps closer towards ensuring that a multitude of perspectives have been considered, weighed, and balanced in arriving at decisions. Inclusion of women in the judiciary will also ensure that decision-making process is more responsive, inclusive, and participatory at all levels. It may be apposite at this juncture to attempt to capture the sentiments of Judge Vanessa Ruiz, the senior-most judge of the Court of Appeal of the District of Columbia, United States of America, and the president of the International Association of Women's Judges, when she said, and I quote, "By their mere presence, women judges enhance the legitimacy of courts, sending a powerful signal that they are open and accessible to those who seek recourse to justice." In this context, that I stress on the importance of altering the demographics of the judiciary, whether the district or the higher judiciary, to include more women judges. Legitimacy is a significant requirement of any decision-making body, and a diverse judiciary, which gives not merely symbolic but substantive representation to women, is indeed a necessity. Out of 735 judges, which is the total strength of the Supreme Court and all high courts, only 87 women are women. The problem of underrepresentation of women in the judiciary is not limited to India. The representation of women, even in the International Court of Justice, constitutes a mere 20% of the total strength of the World Court. What I find to be a refreshing gender balance and a nearly appropriate gender ratio has been demonstrated in the International Criminal Court, which is 9 women judges out of the total strength of 18 judges. We often find that women enter or get into the legal profession, but not many get up. The glass ceiling implies the existence of an impermeable barrier that blocks the vertical mobility of women. It is important to look at 3 main phenomena: the entry of women into the legal profession, the retention of women, and growth of their numbers in the profession, and 3, the advancement of women in numbers to senior echelons of the profession. To this end, the requirement of women lawyers need to be recognized and provided for. These requirements may be as basic as provision of adequate sanitation and hygiene facilities in the court premises, permission to appear in legal proceedings through video conferencing, or sometimes even general acts of courtesy towards women, such as offering a chair in the crowded courtroom, making way for women to easily enter or exit the court hall. How should female lawyers confront the reality of the glass ceiling and chisel away at it until we can break through to the other side? How do women confront the motherhood dilemma? These are questions that we as a legal fraternity need to deliberate and concertedly act upon. A long-standing obstacle to equal opportunity involves the mismatch between characteristics associated with women and those associated with professional success, such as assertiveness and competitiveness. Women still face a long-standing double standard and a double bind. They risk criticism for being too soft, too strident, too aggressive, or not aggressive enough. Further, what appears assertive in a man often appears abrasive in a woman. A related obstacle is that most often women lawyers do not receive the same presumption of competence or commitment as their male colleagues. In large national surveys, between half and 3/4 of the women believe that they are held to higher standards than men. The problem is understandably compounded for women belonging to some other identifiable minorities, such as disabled women, women belonging to the LGBTQ community. The performance of these groups is subject to special scrutiny, and their achievements are often attributed to special treatment rather than professional qualifications. The force of traditional stereotype is reinforced by other biases in decision making. People are more likely to notice and remember information that confirms prior assumptions than information that contradicts them. For example, seniors who assume that working mothers are less committed tend to remember the times that they left early, but not the nights that they stayed late in office. People also want to believe that their own evaluations and workplaces are meritocratic. If women are underrepresented, the most psychologically convenient explanation is that they lack the necessary qualifications and commitment. Moving on, Ensuring that the workspace is free from discrimination and violence is critical to the empowerment of women. Sexual harassment, particularly at the place, is a gendered expression of power. Sexual harassment is a form of discriminatory conduct which hampers women's constitutional right to equality under Article 14 and dignity under Article 21 of the Constitution of India. Until the late 1900s, the constitutional equality and dignity was not the lens through which a woman's experience of sexual harassment was viewed. Vishakha was the state of Rajasthan, was therefore a visionary decision in many ways. Sexual harassment at the workplace is a problem for which women pay a substantial and disproportionate price. Many experience both economic and psychological injuries such as loss of employment, opportunities, unwanted transfers, anxiety, depression, and other stress-related conditions. Organizations pay another price in decreased productivity and risks of legal liability. Legal employers and bar associations must be prepared to translate principles into practice and to hold their leadership accountable for the results. Senior lawyers in positions of influence need to build a moral and pragmatic case for diversity and to incorporate diversity goals into the ethos of the legal profession. The governments across the country can provide impetus for inclusion of qualified women lawyers in their panels by at least 30%, ensuring that work is assigned to them from across the spectrum of laws. Further, courts across the country can appoint more women as amicus curiae to assist on issues of their expertise, more compulsorily on issues concerning rights of women. On this occasion, let us reaffirm our commitment towards creating inclusive and gender-sensitive legal profession and judiciary. Justice does not live only in courthouses. Individuals and organizations in the community are valuable justice system partners in the quest towards more equitable justice delivery. Collaborations between justice system and system stakeholders and community organizations can help people through upstream interventions that get closer to addressing the roots of where inequities manifest. Partnerships with communities and early educators to increase the pipeline of new, diverse generation of lawyers and judges can make longer-term changes to the makeup of the judiciary, creating a system that is truly representative of the people itself. In conclusion, I must state that to realize the promise of equitable justice delivery, the judiciary is to be, in every sense, a strong institution that is accessible, efficient, and committed to protecting the rights of all citizens, particularly the vulnerable. On that note, I thank the Supreme Court Unit of Adhivakta Parishad for inviting me to address you all this evening. I thank you for your kind attention. Namaskar.
Thank you very much, Sonia ji, for reading out those golden words. Though we could not hear Honorable Ms. Justice Nagarathna, but even hearing those words were quite an enlightenment for all of us, I'm sure. In fact, in the recent function which was held by GSICC, I remember Honorable Ms. Justice Nagarathna has said, women do not want to be put on a pedestal. We only want equal treatment. So with that, we come towards the end of our program. I would now request Advocate Rashmi Singhania ji to kindly come for a vote of thanks.
Namaskar. I, on behalf of Adhivakta Parishad Supreme Court Unit, offer our sincere gratitude to Honorable Ms. Justice Hima Kohli, Judge Supreme Court of India, who accepted our invitation and graced us with her esteemed presence today. We also extend our sincere thanks to Honorable Mrs. Justice B.V. Nagarathna, Judge Supreme Court of India, though she could not join us today, but we are thankful for sending her speech on the subject. We are thankful to Mr. S.N. Bhatt, Senior Advocate, for enlightening us on today's topic, embracing equity in justice delivery system way ahead. Honorable Ms. Justice Hima Kohli enlightened us that equity is the vehicle which takes us to the goal equality. She also drew our attention on the fact that the word equity is nowhere mentioned in the Constitution. She explained us the role of the judiciary in promoting equity. Thank you, Your Ladyship, for elaborate and the motivational explanation. We thank Mr. S.N. Bhatt, Senior Advocate, for explaining us the word that equity means those who are already equal and taking us to the ancient stories. Thank you, sir, for the encouraging words. We also thank Honorable Mrs. Justice B.V. Nagarathna. Though she could not make it today, but we sincerely thank her for sending her speech for the August gathering here today. Women do not need to be empowered. They are the power. And in the long-held patriarchal hierarchy, takes time to manifest itself, working its way up like a trellis through gaps called opportunities. As it is said in the old scriptures, Yatra narastate pujante ramante tatra devata. The modern version of this is that if a country needs economic and social prosperity with 6 to 7% rate of growth, you must not only include women, but you have to establish them and place them in leadership positions. I thank each and everyone in the audience present here who have taken out the time from their hectic schedules and increased the grandeur of this program. I also like to give due credit to the immense help and support of the Adhivaktas of Akhil Bharatiya Adhivakta Parishad who have worked extremely hard to make this program a huge success. Coming to the end of the program, I would like to recite a few lines. माँ बस यह वरदान चाहिए, जीवन पथ जो कंटकमय हो, विपदाओं का घोर वलय हो, किंतु कामना एक यही बस, प्रतिपल पग गतिमान चाहिए, माँ बस यह वरदान चाहिए. Now, I request everyone in the auditorium to kindly join us for the national anthem. जनगण मन अधिनायक जय हे भारत भाग्य विधाता. पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा, विंध्य हिमाचल यमुना गंगा, उच्चल जलधि तरंगा. तब शुभ नामे जागे, तब शुभ आशीष मांगे, गाहे तब जय गाथा. जन गण मंगल दायक जय हे भारत भाग्य विधाता. Vande Mataram. Thank you all. Namaskar.
दोनों भी जाएंगे ना
क्या है क्या हैं पूछ तो होगा जब कुछ हाँ वो तो इसको बता पूछ लो